Okay, my clock just turned 4:30, so we can get started. So, thank you for joining us today. My name is Ben Rhodes. I'm the Senior Vice President with CAMS. We are here today to talk about meetings, all about meetings, annual meetings, board meetings, special meetings, and electronic voting. And we may throw in a little bit of Corporate Transparency Act just for the fun of it. So with us, we have Harmony Taylor from law firm of the Carolinas. She will lead us through this presentation and talk about all those things that you're getting ready to get into the season of. So um, we will take questions from the floor, but we would like for you to use the Q&A feature. So if you can type your question into the Q&A, that's at the bottom of the screen, on the side of the screen, depending on what you're using. But you can type your questions, and I will help facilitate those questions for Harmony to ask or answer throughout this session. So we also are recording the webinar. So if you would like um, to share that information with other board members, it will be posted on the website of camsmgt.com, board member resources. So you can find the webinar probably Monday next week. It will be posted. So hope you can share this information with your other board members. We do have all of our other webinars posted there as well. So lots of great content for y'all to watch. So Harmony, I will turn it over to you and yeah, lead
All
us
right,
through.
ready to get started. Good afternoon, everyone. I was just taking a moment to look through the list of some of the participants to see who I knew, and I see some familiar names. So thank you so much for being here. Again, Harmony Taylor with Law Firm Carolinas. I'm located in Charlotte, and my firm has offices across North Carolina and South Carolina as well. There is nothing that I love more than the sound of my own voice, as Ben knows, and so he's always gracious enough to allow me to come and talk to you guys about different issues that come up during the year. I have a list of topics I want to talk about. I don't have a PowerPoint because I hate them and I always end up advancing too fast. So this is going to be a little bit on the fly. If you have any questions, please do share it to Ben. One of the nice things about getting to this point in my career where I've done this area of law for over 20 years is I'm able to say, you can just ask me a question and I can answer it like this, and I don't have to be quite as worried about prep. First, I want to talk about, what are annual meetings? Every planned community and condominium created in this state under 47C, the Condominium Act, and every nonprofit in North Carolina is required to hold an annual meeting. And the purpose of the annual meeting is to conduct the business of the association. And as you know, that's generally updating the membership on the prior year, discussion of the financials and the budgets, election of officers or directors, voting on matters that might come before the association. And the fundamental idea of all of this is that the members will be given an opportunity to really be involved in their community in a way that they are not throughout the year, because members don't automatically get to attend board meetings. They're allowed to attend board meetings at a regular interval, which is probably once or twice a year. But otherwise, the annual meeting is really the meeting for those members. The annual meeting is called and administered by the board, but sometimes the board forgets that this is really a meeting for the members. So if owners want to stand up and discuss matters, that's completely appropriate, and this is the forum where that should be done. It also means that because the meeting belongs to all of the members, that no one member should be given the ability to take that meeting for themselves. And many of you on this call will know that you have someone in your community who likes to stand up and speak at every meeting, and they want to raise the same issues over and over again, or they may be even dangerous or threatening or difficult during the meeting. And that's why it's so important during these annual meetings to follow some appropriate rules and regulations. These are not meant to stifle people from asking questions or speaking when appropriate. It's to allow everyone to fully participate in the meeting without feeling that they are being singled out or bullied in a way that would keep them from speaking. Every planned community in North Carolina and condos are obligated to operate under Robert's Rules of Order unless they have another parliamentary procedure they follow. And I have only seen that very infrequently. So basically, they're obligated to follow Robert's Rules. Robert's Rules it's a huge book. If you've ever looked at it, it's about that thick. And my partner, Jim Slaughter, has written multiple books on Roberts. Most of us don't want to delve into the nitty gritty of that. And instead, we focus on the broad strokes. And Roberts says that for small deliberative bodies, such as homeowners associations, that you can take a more relaxed approach to the rules and regulations and how you operate the meeting. But you still want to have some basic rules that you follow. And that includes things such as having an agenda, following the agenda, recognizing those who are going to speak, allowing them to speak uninterrupted, and allowing others to speak instead of allowing one person to take over the entire meeting.
Hey, Harmony.
Yes.
Just I know the question already came in with South Carolina. We do have some folks from South Carolina on the call as well. So if you could maybe reference some North Carolina and South Carolina, because it's very similar but different. So
Yes. Well, and I'm going to give the caveat that I'm not a South Carolina lawyer, but my firm represents associations throughout South Carolina. South Carolina is a little bit different because they have their own nonprofit act, and then they have the Horizontal Property Act, which addresses condominiums in certain communities. But otherwise, South Carolina is sort of the wild South, not in the Wild West, when it comes to meetings, and often they operate under their own rules in conjunction with parliamentary rules such as Roberts. But in either case, it's incredibly important to have a good agenda and have some general rules that are going to regulate how the association operates. Sometimes, and we've talked about people taking over meetings, I'm seeing more frequently boards of directors wanting to have security in the form of law enforcement at meetings. If that can be avoided, it should be. I'm not a fan of having law enforcement there because it does appear to stifle some communications. But sometimes communities say, we always have an officer there, an off-duty officer. Maybe it's someone who's able to give us a community update on crime in our neighborhood as well and be there as a security feature. So that's another way to keep order and to make sure that everyone feels like they are safe and have that full opportunity to speak. Another thing about meetings is a meeting in after COVID can be held in a wide variety of ways. It can be held by a conference call, it can be held by Zoom, and it can be held in person. And more communities are moving to these electronic formats to allow additional people to attend. The problem, I think, is that to date, our technology is still not quite caught up to give people the full opportunity to attend to these meetings and feel like they're participating when it's by Zoom. So business can be conducted, but just keep in mind that that does make it more difficult for people sometimes to fully speak and to be heard in the same way. Just as here we are now, this is a very different experience than if we were all sitting in a meeting and I could look at you and see if you were nodding or had questions. There is a level of disconnect a little bit, and the proper steps can go toward helping that not be the case. With electronic meetings, and I'll go into this a little bit later, it's important to have your own separate rules that let everyone know how they're going to connect, how they can access the information, the proper way that they would ask a question or be heard to be recognized to speak, and also address connectivity issues because the association can do its very best to have everything set up, the electronic format is working, but if an individual owner has a connectivity issue, the association can't address that. And owners need to know that up front, that a meeting will not be stopped because one or more owners simply lose access to that. So we talked about the annual meeting and what sort of generally happens at that annual meeting. We have discussions from prior year, financials and budgets, elections of officers, voting on different matters for the association, and the opportunity to speak. Budgeting is one of the biggest issues that most associations are dealing with at the annual meeting. And the budget ratification process is fairly similar for communities across the state. Every condominium in North Carolina is required to follow a particular statutory process under the Condominium Act, and that's 47C3 103C for those who want to look it up. And that generally requires within 30 days after adoption of a budget, the executive board provides the budget summary to all of the unit owners. The board sets a date for the ratification meeting, which may be the annual meeting, but doesn't have to be. No quorum is needed at that meeting, and the budget will be ratified unless a majority or any higher amount that's specified in the covenants or bylaws rejects that budget. Frequently, there are going to be internal limits within the community's own documents about how much the assessments can go up in this way. So that budget ratification process may be fine as long as the assessments are not going up, for example, more than 10%. But if they're going to be higher, there may be some additional thresholds. I think a lot of times it's confusing to boards and to the participants to understand that this is not a situation for budget ratification where the members have to vote to ratify. The budget is ratified unless the owners reject it by a majority of the votes. So when I go to a meeting and the budget is set for ratification on the agenda, if we don't have 50% of all of the owners there representing the vote in person or represented by proxy, we don't even need a motion to ratify the budget other than to put it in the minutes of the association, because that budget is going to be ratified. It can't be rejected because we don't have enough people or vote represented there. And we can talk a little bit about how, if this is done via a written ballot, sometimes associations will send out the budget to be ratified by written ballot. And we did find during COVID that a lot more budgets were not getting ratified because people who were not going to show up at a meeting and vote were willing to send in a ballot back in and say, no, I reject it. So that was the first time I began to see on a consistent basis communities coming back where they had 51%, et cetera, of owners who were actually coming in and saying, no, we are going to reject this. The Planned Community Act, which applies to planned communities in North Carolina, has the same process set up, but that language is not retroactive. So if a community's covenants were filed before 1/1/99 and they haven't adopted the Planned Community Act or have really similar language, then they don't have to do the budget ratification process. And that also can be very surprising to new owners as they come in and find out that some associations have no obligation to do anything when it comes to actually getting that budget before the members for a ratification. But even if an association did not have the requirement to bring the budget before the members, of course, you want to, as a nonprofit and as board members with fiduciary duties to your membership, you want to make sure everyone is aware of what you are spending the money on. Because money that comes in can only be utilized for the purposes set out in the governing documents, the Articles of Incorporation, the Declaration, or the bylaws. We have set uses of those funds, and we want the owners to know because we want the owners to be able to budget and pay their assessments. And owners have to understand, of course, that all of the board members are paying the same assessments. They have their own interests in making sure that those funds are not excessive or not going to unintended purposes. But I'm going to say something that I say all the time, and I think really needs to be taken to heart. Budgets should go up every year. If your assessments are not going up and your budget amounts are not going up every year, that is almost certainly a problem because everything else goes up. Your costs, your insurance, your costs of landscapers, any labor, all of that, your professional services go up. And the association is acting within the best interests of the entire association by taking advantage of increasing budgets where they can. No one is recommending, of course, that you go up to an excessive amount or that would put people in dire straits. But we frequently see, and by we, I mean your professionals and your managers in particular, associations in trouble because they haven't raised the assessments when they could. And then after the fact, they're trying to make that up. And making those funds up through a huge increase in assessments, which may require a vote, or a special assessment, which is unplanned for, is not ideal for anyone's budgeting. We would much rather have the assessments go up a small amount each year and have those extra monies that are collected put in reserves for future expenses to take care of maintenance as it comes up and to not create a large expense down the road. And I am well aware of having attended hundreds of these meetings that nobody likes to hear that. And many boards will pat themselves on the back saying, we haven't raised dues in multiple years, but I don't think that's a good sign. And inevitably, we end up with a later board upset the prior boards didn't collect enough money and trying to do that. Elections are also what typically happens at the annual meeting. And communities seem to me to either have hotly contested elections where a small number of people are vying for spaces and they are really campaigning, or you have communities increasingly where unfortunately no one wants to serve. And what we would, of course, like is something sort of in the middle where we have good interest in serving on the board. People rotate over time, so no one is forced to serve forever. And we always have volunteers stepping up to do that. We know this is a thankless job. I serve on my own ARC. I am hoped to never have to be on the board of directors, but communities have to have boards to operate. Nonprofits have to have a board of directors who can make decisions for the community and spend funds. And unfortunately, or fortunately, associations can't simply rely on their managers or other professionals to do that. If you have the unfortunate situation where no one wants to serve and everybody resigns or you don't get volunteers, in those situations, we end up having to call special meetings and letting the membership know, look, someone's going to have to step up and take care of this, or we're not going to be able to operate. Your association could have some significant legal problems there. And hopefully that won't be the case. In an ideal situation, you've got a board, 3 to 5 people who are serving with staggered terms. Hopefully, these are individuals who are property members or who are well invested in the community. And most communities will choose typically to conduct the voting on the directors during the annual meeting, if that's an in-person meeting. The other option, of course, is to, and that allows us to immediately announce the results. The other ways to do this would be by a written ballot outside of the meeting. And sometimes communities want to have this voting take place before the annual meeting so that they can announce the results there. They can do it afterwards, which leads you, sometimes you end up having this lame duck board that sits for some period of time while we're tabulating. Or you can, of course, conduct the voting at a virtual meeting. Virtual meetings are a lot more complicated for voting purposes because we have to make sure that everyone has received notification that the meeting is going to be conducted virtually. It's going to go by, the voting will take place during that meeting by electronic format, and we have to make sure that everyone is set up and registered to use that format there. Whatever it happens, and whenever the voting is concluded, there should be an announcement of what happens. And under Robert's Rules of Order, there should be a teller's report. Most communities tell me they've never done that, but a teller's report is basically a memo that says who was up, who was being voted upon, who received what number of votes, total number of votes, and then it will be signed and dated by the individuals who volunteered to help tabulate that. Sometimes boards don't want to produce a report like that because they think it would be embarrassing to someone to see that they only got 2 votes and other people got 50 votes. Robert specifically says that that embarrassment is not the basis to not do the report. I'm a fan of the teller's report because I do think it gives owners a sense that they know what happened in the voting, because a particular vote is who voted for whom is not going to be shared with the membership. That's confidential. But who got and what number of votes is really helpful, particularly where you have contested elections, because that way someone can see, okay, I only got 10 votes. My neighbor got 300 votes, so I'm less likely to contest that. And if the vote's very close, then we can determine if we need a recount or something like that. So that's why I think a teller's report is great. We have a form I'm happy to share with you. It's also available probably online at Jim Slaughter's website, his parliamentary website, and you can just download it. It's a Word document.
Harmony,
So,
couple of questions
sure.
on budgeting. And so what happens if the budget does not pass?
So sometimes there's very specific language in the governing documents. We'll talk about what happens when the budget doesn't pass. But typically the prior year's budget will roll over, and that will just continue unless and until a new budget is proposed. The association is not left in a lurch where it can't collect anything. It will just stay at the current year.
Okay. Other question you mentioned, so if a budget is put forward and the membership either rejects it or doesn't have enough membership there to take action on it, how does that get reported in the minutes?
So if the membership, if you get a quorum of the meeting or the meeting takes place, the budget ratification meeting, no quorum is needed, and you don't have enough owners there to vote it down, it can simply be recorded as budget was ratified as not rejected by a majority of owners. And
Okay.
that
And
can simply be done like that.
yeah, and so for South Carolina, I can certainly speak to South Carolina processes as far as there are notice requirements. I believe it's 48 hours you have to give notice. And then all the budget ratification information that you're sharing is specific to North Carolina statute or your governing documents. So in
Correct.
South Carolina, it's all about governing documents. So
Yeah.
anything more to add on that one?
No. Again, the budgets typically get ratified because usually you don't have enough people to show up to reject them. I have had boards who have had budgets rejected, have sent out the same budget later, and then have held additional meetings in an attempt to get a meeting eventually where not enough people show up to reject it. And of course, that's a bad idea. If your membership feels strongly enough that the budget that has been proposed is problematic for some reason, is excessive, they don't care for that, the board really needs to look at what the basis of objection is and figure out, is this an educational issue or do we have a charge that we simply don't have the support for? Where this gets really tricky, of course, is that often you have budgets that have included big expenditures that the board has no control over. For example, insurance premiums go up dramatically. You have a massive sinkhole in the common area that has to be taken care of. That's where we want to make sure that the membership is being educated about the use of the funds, because we so often hear people expressing concern, lack of trust for the information they're getting because they just don't have the full story. And we could do an entire presentation on records that members are entitled to receive. Members are not entitled in North Carolina, or I believe in South Carolina, to review each and every receipt, invoice, email back and forth from a vendor, things like that. But boards should consider when they're asking for significant increases whether or not it makes sense to provide some additional information to the membership, because this is your neighbors. We want them to know why we need an extra $50,000 for grounds maintenance if that's to fix a sinkhole. Provide that information in advance and understand there's going to need to be some education there. Owners come forward at every annual meeting and use the T word, transparency. They want more transparency. Often a lot of information has been provided by the association and the management company, and owners just haven't read it. That's okay. That's just human nature. But let's engage in an overkill process of sharing the information we need to get support, so that everybody really understands where those funds are coming from, so you don't have a budget that gets rejected like that.
Okay, there are more questions. Would you like to continue on talking
Sure. Let's
or
go ahead and
okay,
do the
and then,
questions.
oh, you want to get into okay.
Why not?
So first question. This has to do with electronic voting and motions from the floor. So how, if motions from the floor and or nominations from the floor are specific to our governing documents, how do we do that with electronic voting?
Well, I certainly can't address any specific governing documents, but in North Carolina, an association board may decide we are going to hold our meeting online electronically, and all voting is going to take place during that meeting electronically. If that happens, then the board can decide what mechanism to use. Sometimes boards will say, we have a very small community, we have 25 homes, we can simply do everything by chat during the meeting, and that's sufficient. If you've got a larger community, then you're going to need to have some format that can be utilized either through a link that the management company provides in a chat or provides by email prior to the meeting, where everyone will click on and be able to vote. There has to be a way in real time to add individuals who are nominated at the meeting from the floor, unless for some reason the governing documents specifically provide otherwise. And sometimes there are nomination committees and everybody has to be nominated in advance. And so we all know who the nominees are before, and there's some prohibition against later people. But where there are other nominations, these formats that are used can add additional people during the meeting, and that tends not to be a problem. We've seen that successfully done with a lot of companies and management company platforms.
So And you can correct me, and I've been told, and you can tell me whoever told me this is wrong, but that if you send out an invitation and a call for candidates prior to the meeting, that satisfies the nominations from the floor requirement. Um, is that a correct statement or not?
It can, unless there's something in the governing documents that says we will allow nominations from the floor.
Okay.
But yes, I mean that is a good way to do it. And that gets into sort of the issue of proxy, which you didn't ask about, but proxies can be tricky with virtual meetings as well, because if someone just shows up and I want to text or to chat to Ben during the meeting, hey, I've got the proxy for three of my neighbors, that makes it difficult to run the meeting. So with proxies in electronic meetings, we often say you have to turn in the proxy before the meeting and register it, and it can be, up to 24 hours before the meeting, or have some other window of time where that is provided. North Carolina law requires that we take proxies at the last minute if there's an emergency or a particular reason. For example, I'm on my way to the meeting, or I'm getting ready to log into the electronic meeting, and I have to go to the hospital, and the last thing I want to take care of before that is to make sure that I give my proxy to someone else. I could text my neighbor, hey, I'm giving you my proxy to vote. And as long as it's got enough identifying information, that is sufficient. They can then turn around and contact the manager. But probably many of the people on this call have been to a meeting where someone has showed up with 20 proxies right before the meeting. That is a disaster. And it's a real disaster if it's an electronic meeting. You can put in the meeting rules and regulations that are shared in advance that we are going to require that those proxies be turned in and registered prior to the start of the meeting to avoid that issue, so that then when someone casts their vote, they're given that proper weighted average.
So, should our agenda indicate the length of time an individual gets to speak on a specific topic?
Absolutely. I'm a huge fan of formal meeting rules, and I think associations can adopt these in advance for all of their meetings, saying we will recognize people to speak for 3 minutes. After that, we will go to the next person. If no one else wants to speak, we can consider giving them an additional 3 meetings if that is appropriate. Sometimes if it's on this not on the same topic, they can talk on a new issue. All of that should be in the meeting rules so everyone knows what they are and they don't feel that they've been just suddenly had this sprung upon them.
So, can you discuss some best practices in how to present bad news? For example, rates of inflation or special assessments.
I think that communicating early and often is the best way to do that. Most associations are not getting bad news 10 minutes before the meeting. They're learning that they are going to need to do this big project, or that the insurance premium is going up 40% at some point prior to the meeting. I think that it's great when the boards can send out a blast to the members saying, one of the issues you need to be aware of is X. Most people are not going to read that, but those who do will be those who are very interested, and this will give them some additional information and time to sort of come to grips with the bad news and then bring it up at the meeting. Sometimes boards will have additional update forums in advance of an annual meeting if they have a hotly contested issue where they need to ask for a lot more money to share that information. What I'm talking about here is more work for the board, but it does tend to work better when you share that information early and often, because just as you would if you get bad news about your home and suddenly you find out you have a giant project you have to pay for, people are going to want time to think about that and to come to grips with it. And so we want them to get that information as soon as possible. If it has to happen at the annual meeting, do it then, but it's ideal to have it done in advance. And anyone who is shocked to hear that prices are going up is living under a rock. And that's just the truth.
So, what happens if board member election is uncontested? You have five board members running for five spots. Does a vote have to actually occur?
It doesn't. Someone can move to approve that slate of candidates by acclamation, and then we do a show of hands up or down. that's a great way to do it. You don't have to do the ballots and everyone just gets elected.
So, can you talk maybe about the board approval process versus the ownership or membership ratification process? So, does the board ratify the budget and or clarify that?
Well, I am so pleased that as an attorney, I don't have to be involved with budgets very often at all. The budgeting process is something the board of directors works on closely with the management company to come up with, and the board of directors adopts that budget after doing their due diligence and investigating all of the various costs and obligations they're going to have. Once that budget is adopted by the board, that's when it's sent out for ratification by the members. So it's a two-step process. The board creates the budget, sends it to the membership. The membership has an opportunity to look at it, and then the budget is ratified in most circumstances unless it's rejected.
Can you clarify what I think you said about registering the proxy?
Yes. So in North Carolina and in South Carolina, individuals can express their wishes without being present through use of a proxy. Robert's Rules of Order disfavors directed proxies, and a directed proxy is one that tells someone what they have to do. So if I give Ben my proxy and say, I want you to go to the meeting and I want you to vote against Steve and Jim no matter what, that's a directed proxy. That isn't really a proxy as they're meant, because a proxy says, I can't be there. I'm giving someone else my authority. We favor, because Robert's Rules does, a general proxy which says this person can go and do anything in my place that they would have, that I could have done. When I talk about registering that, it's helpful as an administrative matter for an owner who is intending to come to a meeting with a proxy to let the management company know, or board know in advance that they have that proxy, so that just that can be written down. So everyone understands that when they vote, they will be voting not just for themselves, but for other people. And it lets everyone make a note about weighting of that, weighting of the vote. So if I have 5 proxies, I'm going to get 6 votes, my vote plus these other 5 proxies. That's what we want to do. And I've attended many meetings where a couple of managers are sitting at a table checking in multiple proxies to make sure that they're from valid owners, that they're signed, that they're dated, things like that. And that takes away from everyone else's meeting. Then everyone else has to sit while that's happening. So it is appropriate for the board to say, this is how you have to register that proxy in advance. Another issue that comes up here a lot is sometimes boards will come to me and say, we've received a proxy from someone, but it wasn't our form. And no association is ever obligated to send out a proxy unless their documents specifically say that. We do send out proxies because we need people to show up at the meeting, or have representation there to vote. But it's not an obligation to send it out. And a proxy can be really any form, as long as it clearly gives the person authority to act for themselves at the meeting. It has a place for their information, their name, their date, and their property address, so we can verify that. But someone could write it on a sticky note. They can email. All of that would be a sufficient proxy. We just want an opportunity to check that in before it's time to actually start the meeting.
Okay, so we manage, or at least we prepare our budgets 60 to 90 days prior to the start of the coming year. Then expenses change, and I'm paraphrasing this question, but then expenses change. How do we address those changes in expenses in the new year when the budget may not match the actual expense? What do you do to reconcile the difference?
Well, a budget is a plan. It's just how you plan to spend the money, and almost inevitably, the budget will not be actuals. And that's why you have a reconciliation at the end of the year and say, we plan to spend $5,000 on pine straw. It ended up costing $5,800. So the board has to determine over the course of the year where those extra funds will come from. And that's why when these budgets are prepared, then they have some wiggle room in there. And there are circumstances where you have to dip into the reserves, you have to dip into contingency funds, or decide over the course of the year you simply can't afford to do something discretionary because of your financial obligations there. It is not a problem, and if the board has a deviation between the budget anticipated and the budget actual, that just simply reflects the reality of the world. And when you need to explain that to the members. This again is your plan. We set the assessments. That is a set amount. But just because we have $5,000 for Pine Straw doesn't mean we will spend 5,000. It could be more, it could be less, whatever that is, but this is our plan. And that's what the membership gets the feedback on.
Okay, I have more questions, but I didn't know if you wanted to continue on with what you had prepared to talk about, or unless you want me to ask more questions.
No, I just wanted to go through a little bit about the voting issues because we do have so many questions frequently about different ways of voting. In North Carolina, if a board of directors calls a virtual meeting and the meeting will be held virtually, all attendance will be during that meeting in a virtual format. The board can dictate that all voting is going to take place in that electronic format during that meeting. The only time that you would not be able to do that and would have to give a sort of a dispensation to someone is if you had a specific disability issue. For some reason, someone absolutely could not, or they contact the association and said, we have no access to electronic voting. In those circumstances, we typically would recommend that the association make some provisions for them and give them an additional way to vote. That's for a vote during the meeting. We also talked briefly about how you can send out a ballot after the meeting or before, and a written ballot can be used in North Carolina for any matter that is before a membership for a vote. A written ballot has to have a hard and fast must be received by date. So it has to say we must receive this ballot back by September 30th at 5 p.m. in order for it to be counted. And that deadline, once it is set out, cannot be extended. So if we come up one vote short on that date, we're going to have to start all over again the next time. In certain circumstances, you can use a written agreement process, and we most frequently talk about that for amendments to covenants because that's a specific statutory procedure. Boards will frequently suggest that we could vote on an amendment during an annual meeting. And I have attended very few annual meetings where we had enough people to actually pass an amendment to the declaration. Bylaws is different because usually that's the majority of a quorum, but the written agreement process is specifically used for amendments. That is a document we send out. It looks like a ballot. It has a return by date, but that date can be extended, and that's a little bit different way. But we don't use the written agreement for anything really other than adopting amendments to governing documents. We're going to use a written ballot if it's out voting outside of a meeting for anything else. And we can allow owners to vote by proxy as well. When it comes to voting outside of a meeting, however, my position always is we don't need a proxy. If Miss Brown can execute a proxy for someone, she can also execute the ballot. And so we just send them the ballot instead and allow them to vote the way they want to do that. I think it really comes down to a lot of politics. And I don't say that in a bad way about whether or not you hold votes during the meeting or after meeting. There are compelling reasons to make everybody who's going to vote on something be at the meeting. They have a chance to hear what's said, to interact with their neighbors, and to really get the feel of the issue in person. When you have votes after the meeting, often you have people voting who have not bothered to read the information provided. They're not really informed. They're just simply voting based upon the document before them. But it's ultimately up to the board of directors how they decide they want to hold those votes. And this is something that boards, as long as they're not doing for an improper or nefarious purpose, they have broad discretion to make those choices. Then I think that's all I had until I got into my other issues here. So I'm happy to take additional questions.
Okay. So we have 5 board members and 4 are new as of last January. We typically have 3-year terms. How do we transition so that we have more staggered terms amongst the board?
It depends on whether or not the governing documents provide for staggered terms. Often we have to do an amendment to the bylaws to get that in place. And as I said before, often that just requires a majority or 2/3 of a quorum at a meeting to do that. And we do a reset. Sometimes boards will simply, we can do it within the existing documents, and you have directors who are willing to accept some of them a longer, some of them a shorter term. But staggered terms are always preferable. No one, we don't want a brand new board coming in every year. And that usually does require a bylaws amendment with a reset in those staggered terms.
So I think maybe in this case they got off the staggered period. So could one resign their role at a specific time and then start a new term or and
It's hard for me to know just sort of generally, but yes, I mean that can be done. I have created more charts of board terms and who went on and off than I care to remember. And if you've got a board that works cooperatively and says, "Sure, I'll take the space number 4, and we can work it out," that's fine. But it's a great thing to pursue if you can.
so I have a suggestion for this next one, but can you provide any suggestions on how to get more homeowners to attend our annual meetings? We have 200 homes and only about 10% show up.
Right. Well, I want to hear your suggestion first.
I'll say it works every time, but you threaten to raise the dues a lot, and generally you will get a lot of people showing up at the meeting.
That's true. I have heard everything under the sun from, cookies being offered to raffles, bingo games. One thing that I absolutely recommend against is a bar. An open bar is always a terrible idea to offer. I think putting issues on the agenda that make people want to talk about is important. Having different community liaison off, having officers come in, having people from outside the community can help. Sometimes people even have, local representatives or people running for office show up. The best way to do that is to go door to door to talk to people, to explain it's a small amount of time and this is an opportunity for them to know what's going on in their community. I think that the personal outreach is about the best you can do. If you've got a lot of absentee owners and people who just consistently have not cared, you may have to do some threatening about what the board might do. And you may also want to consider, does a virtual format work better? And I would tell communities, sometimes they'll say, I think a virtual format would be difficult for older owners. I actually find that's the opposite. A lot of older owners like not having to go out at night or being able to simply log in from home. If you've got people with disabilities, that can give people greater access to meetings. So try different ways of handling it different times and see what will get the most involvement.
Yep. Zoom meetings have increased participation, so that's definitely a good suggestion. And I say raise your budget in jest, but it does bring people out. It also having generally people will show up to board meetings or annual meetings when there's issues, right? When there's problems. And so if you don't have problems and people don't show up, that's not always a bad thing. But it is good to communicate out what are the things you're working on? Tell people,
Right.
educate people, how to make it improve the messaging.
I'm sure we both work with many communities where the same people have been on the board for years because no one else wants to serve. That's often a great thing to highlight on the notice. This person has been on for 5 years and we're happy to have new blood on the board. Please show up, because I don't like it when people come back later and complain. We have the same directors. Well, have you served? I tend to be the attorney who will stand up at the meeting and say, you can't complain if you've never volunteered or run from a position on the board. I think that should be a prerequisite before you can kvetch about anything.
So you talked a little bit about Zoom meetings early on. How do you let people have their 5 minutes or 3 minutes properly to allow them to speak to a specific issue in advance of a meeting or during the meeting?
By Zoom?
Well, via Zoom, yes.
Right. Well, we give people different ways to sign up. Sometimes people will, when they register or when they log in, they will indicate through chat or some other feature how they want to be recognized. And then you will need someone who is helping to administer the meeting by electronic format to recognize that person, unmute them. In my opinion, it's almost impossible for one person to run an electronic meeting. So you have the board of directors there. If a manager is attending that meeting and they are being asked to, handle questions that come in and make sure that everyone is logged in, they have the information they need, you may need an additional person who can help to run the meeting, to recognize those, to unmute them. So having several people help with that is going to be important. And then you simply unmute them, recognize that person, and let them speak.
So with a vote to reject the approved budget, can it be in a mixture of in-person and proxy? And then is the 51% based on the total number of units in a community, or is it specific to 51% of the people in attendance?
It's total of everyone in the community. It's the entire membership. And it's set up by statute deliberately to make it hard to reject a budget. The board of directors has fiduciary duties to set a budget that's reasonable and doesn't include improper charges. And then it does have to be 51% or even higher in some cases of the membership. And that's the entire group. And it certainly can include people who are voting in person or by proxy. If I've got 10 proxy votes with me and cast my vote as well, those are all votes. That counts just like anything else.
We kind of talked about this next question, but if a board exceeds a specific budget line item significantly, um, is there anything they need to do to re-ratify a budget or make changes for the membership to get the buy-in?
That's politically maybe, legally no, because the budget is just an anticipation of how you'll spend the money. It is not a requirement. And if you, like, as I said before, if you budget 5,000 for Pine Straw, you don't have to spend 5,000. But it is obviously a problem if an association is budgeted 5,000 and it's going to be $50,000. That's a gross deviation from that. And in most circumstances, we would talk to the board and say, do we need to do a new budget to increase assessments or to get money somehow? Do we need to reallocate a significant amount of our funds to this other box? Or do we need to simply let the membership know why it happened? And there needs to be some communication, in my opinion, if there's a huge deviation. It's just how we do it and what legal steps we have to take, or it's going to vary.
So to ratify the budget via electronic voting, what steps need to be taken? Is there a motion made, or how does that get presented to the membership?
Well, if you're in an annual meeting, say online, and everybody's there, you would look at the number of votes that are represented. If we have 30% of the votes total represented during that meeting, in person or by proxy, then the board president or secretary could simply say, we don't have the requisite number to reject the budget here, so therefore it is ratified. If you're sending out a ballot or doing the vote outside of a meeting electronically, then you're still going to need a majority of all owners to vote against it. And they would simply just cast those votes and it would be tabulated after the fact.
Okay, this next question involves probably politics, but we have a couple of neighbors who are continual problems for the board. And I'd say just a couple, but they hate the covenants and refuse to follow portions of our documents. We've even had to go to court to get this resolved. We do not want to allow them to run for the board. Is there anything we can do to communicate that that person is not a good candidate for a board position?
Well, that depends. So sometimes there are provisions in the governing documents which specifically state that in order to serve on the board of directors, you have to meet certain qualifications, and that would say you can't be in arrears of what you owe, you can't be in default and have been found in default. If that occurs, then the individual may simply not be eligible to run and they can't run at all. More likely you have someone who maybe had a violation, but it was resolved and they're just a troublemaker. They would be a terrible board member, but they are allowed to run. The association can't stop those individuals from running from the board, but others can absolutely stand up and say, this person would be a terrible candidate for the following reasons. And as long as this is not confidential information, it's information that's generally available, then you can share that. I've had board members stand up and say, I think that Joe Blow should not be elected because he's a jerk. He is constantly threatening the association with litigation. He sued us 5 times, etc. The problem is that most people don't want to have that kind of direct confrontation. And they will contact the manager or they'll contact me and say, Harmony, can you stop them from running? The answer is no. You're going to have to stand up and actually say this person would be a terrible director. They were on the board 3 times. They quit 3 times. They left us in a lurch. All of that kind of thing. That is okay to say. It's not defamation. It's your opinion. Don't stand up and accuse them of, crimes of moral turpitude or illegal acts, but you can say this person would be a bad director. They don't believe in the fundamental concepts of our community, and we think you should vote against them.
And you speak to the difference between directors and officers, and when those officers get appointed, is it at or voted in, is it at the annual meeting or the first board meeting?
So that's an issue that comes up all the time, and that's a great question because I love it when people are precise. Everyone who is on the board of directors is a director. Members in most circumstances, but not all, in most circumstances, vote only for directors. They don't vote for a president or a secretary or any particular position. After the directors are selected, they then meet privately, usually right after the annual meeting or whenever they're elected, and they determine among themselves who is going to be an officer for a 1-year period. So people decide who would be the best treasurer, who would be the best president, etc. The board can internally change those roles at any time. And they frequently will because someone will say, I need to step down as president, but I can remain on, and there'll be shifts. All of that happens again internally there, and those positions are for a 1-year period. Where this often comes up is that people will reach out and say, well, I want to remove someone from the board of directors. Our governing documents say that the board can vote to remove a director. What the documents usually say is the board can vote internally to remove someone as a particular position. They can remove the president as president, but they're still on the board. Only the membership at large can vote to remove the person from the board itself. And that it doesn't matter if the person was elected to the board by the members or they were appointed to fill a term by the board. Once they're on the board, they get removed by the members, whereas officers can be removed by the directors.
Okay. When it comes to reserve spending, does a board need a vote of the community to spend that money, or is it the right of the board to spend?
It's usually within the discretion of the board. I've seen documents which require a particular approval of the membership for financial outlays for certain uses, but usually that is within the boards. Remember, boards of directors or community associations are representative democracies. You elect a board and then they operate the affairs of the association. They're the administrator, so they get to decide. Members not only don't get to, but they don't have to micromanage the affairs. They don't have to approve every vendor invoice or talk to 7 people about who's going to provide the pool equipment. This is something that the board gets to decide to do. And as long as the board is expending those reserve funds for a specified reason, that's fine. Sometimes we do see governing documents that say the board shall reserve in a separate account money for example, roofs. If that happens, then if the money needs to be used for something else, we would want to look at those governing documents carefully and decide, can it be done? Or is this something that would be done, but it needs to have membership approval? And I always recommend membership approval for any huge unbudgeted expenses, and huge is going to vary by the community. For some communities, that would be $10,000. For others, that's $500,000.
So does a reserve budget get ratified like your standard operating budget?
That's going to depend on the governing documents. If they require a certain amount of reserves be put in there, that would be included as part of the standard budget one would expect. And then the reserve funds are held and used out of the regular budget.
Okay, our CC&R state that we have to hold a special assessment meeting for that purpose. Can we combine this meeting with a budget ratification meeting and an election meeting?
Yes.
Easy answer. How do we best conduct a verbal vote at an in-person meeting and still account for proxies? Should it be a roll call vote?
Right. That's hard. That's going to depend on the size of your community. If it's really small and you can say call Harmony and I'll say Harmony plus three, then that's fine. But usually you're going to need something else. And that's when we go into an actual written ballot we hand out and we don't do a verbal vote.
Do staggered terms require change to the declaration and bylaws? Our declaration and bylaws do not address any sort of staggering of terms.
Probably. They probably would require an amendment in order to get there because if you simply have documents to say everyone serves a 1 year term, then you're going to have to move to staggered terms.
If they say until death, resignation, or you see other language that don't specify a term, how do you handle that?
We usually consider that as a default of a 1 year term. You have an election every year. That does not mean that you get to stay on there for the rest of your life or have to.
Or have to, right? Is the percentage for passage of business a percentage of the full community or just the percent of members present? And,
Yeah,
and
I think I understand. Sometimes the documents will say you need two-thirds of all members voting in person or by proxy at a meeting scheduled. If that language appears, that means two-thirds of a quorum. If, however, it says two-thirds of the entire membership or all lot owners, period, that's of the entire membership. So it's really dependent on the language.
so we only have three board members, and the governing docs do not discuss increasing the number of board members. Can the members vote to add two more board members to positions?
That's going to depend on your individual bylaws if they allow it or not.
Yeah, I
But
would think.
remember, you can always have volunteers who assist the board, even if you can't specifically add them without an amendment.
Yep. So you can generally add more officers, but you may not be able to add more directors.
Right. And that could be a weird situation where they don't get to vote, but they can still serve sometimes.
So if we only have e-voting for all homeowners with a cutoff final date and then the annual meeting to announce the results, no proxies are needed and no nominations from the floor. Is this legal? And it's specific to South Carolina, which would be specific to your documents. But can you talk about e-voting and the difference between a informational session versus an annual meeting?
Well, the board is always going to have an annual meeting at some point in order to allow members basically to speak about any issues they want. You don't have to have the budget handled there. You don't have to have elections handled there, but you still have to have an annual meeting to really sort of check that box. Other informational meetings can be held throughout the year. Often, many boards will do that in conjunction with a board meeting, saying we're going to hold portion of that open and have an informational meeting just to talk about other issues. For example, huge expenditures, which we anticipate will come up so that people get some information on that. If your documents allow you to simply hold all of the call for nominations in advance and all of the voting is happening prior to the meeting and it's simply an announcement per se, then that's fine. You're not required to actually do that voting during the annual meeting. The only thing that has to happen during the annual meeting is members have to be given an opportunity to speak and address the board.
Okay, our annual meeting is in October, but our fiscal year is aligned with the calendar year. Is it good practice to provide financial reports at the meeting, including a budget forecast, and then handle the budget development and ratification separately, or do them at one time?
I think it's always great to give a forecast if you can.
Yeah, and I'd agree. The more you can communicate, the better. And um, yeah, just
I
share
think
information.
many members are under the false impression that somehow board members aren't paying exactly what they're paying. and that people want to increase funds for some undisclosed reason. And the truth is, everyone is trying desperately, as you know, to keep these rates as low as they possibly can. Even though I recommended that they go up every year, we want to make sure people understand why that's the case. And that's your informational meeting, your annual meeting, whatever it is a great opportunity for you to say, looks like our insurance premiums are going up. Looks like our landscaping will go up. All of you complained last year that the flowers weren't nice enough. Well, we've put in, another $1,000 for flowers, things like that. So any information you can provide in advance is helpful. If you get a huge amount of pushback on the numbers, that's great. It's not great that it happened, but it's great to know that in advance so you're not scrambling after the fact. So I would absolutely say here, give the anticipated costs in advance and then follow that with the final numbers once you get them.
Okay. One of the last questions, and it's actually the last. So, what happens if someone is elected to the board and refuses to comply with the Corporate Transparency Act? We've gone the whole session without bringing up the Corporate Transparency Act. So, might brief us real quickly, since we may have some new board members that haven't heard anything about the Corporate Transparency Act. And I'll just remind everybody, we have full webinars on this topic. So if you do want to see an in-depth review of the Corporate Transparency Act, we have, I think, two on our website. But
Yeah. And there's a lot of great information out there, and I would certainly encourage anyone who hasn't looked at those webinars or those resources to please do so. If you have a director who refuses to do so, in my opinion, and this is a new issue, there's not a litigation about this, I can't point you to a case. In my opinion, all that the association can do is to tell the owners, the board members, they have to do this. You provide the information, and if you do and they refuse to comply, then I believe they are personally liable for any fines that would be issued. And these are substantial thousands of dollars fines if they are issued. And they would be against the individual, not the association. And I'm going to die on that hill. I believe we can shift that responsibility with the proper disclosures to the owner because we can't make them. Some board members may resign when they refuse to provide this information. Others will want to stay on but refuse to do that, and they will do so at their peril, knowing that they are not providing the information they're legally required to provide. I've had two communities ask me to revise the bylaws to make it a requirement of service on the board that you do appropriate reporting to FinCEN. And I think that's an interesting approach. That would be a basis to then have someone automatically removed from the board. They would be effectively terminated if they refuse to provide that information.
yeah, so the CTA, Corporate Transparency Act, is still new. And so we're all trying to figure out how to deal with the changes. And officially, everybody, if you haven't heard about it, you do need to comply with the Corporate Transparency Act as of January 1st, 2025. So please
And I'll
reach
just
out.
say to that the information that has to be provided is your name, your mailing address, copy your what do I have here? Is your name, date of birth, and then a copy of your unique identifying number, such as a driver's license. This is all information that the federal government and the state government has already in about 50 places. They just want it one more place. And CAMS has a process, a service that they are providing to help people and boards provide this information and to do the appropriate reporting. We strongly recommend you work with your management company to do this, to make sure that you are in full compliance. If you follow their advice, you turn that information in from the people who are willing to do so, that protects the association. And like I said, I believe will shift the responsibility for the few bad actors who won't comply to them personally there. I know people come forward and they say, by God, I don't want to provide this information. I would just encourage people to step back for a minute and say, you know what, this is required by law. I don't think it's going to be required forever. And we were talking briefly about the legal challenges which have been filed. Hopefully this will go away, but in the meantime, get your procedures in place, work with your management company to get this reporting done.
Well, that was the last question. So, Harmony, thank you very
Excellent.
much for your time this evening. The 77 folks still with us, thank you for spending your Thursday afternoon, evening with us as well. So, hope you found the information valuable, and we will see you next time.
All right. Thank you so much for the chance.
Thank you.
Bye.
Bye bye.